Pro Southeast plaintiff cites several violations of general statutes, including Automobile Code Dr. 71058 and X73435, that the insurance defense attorneys Meredith Cushing, Heather Connor, and Jeffrey Kuykendall of McAngus Goodluck & Creek, PLLC, MGCLAWCOM have violated during litigation of an insurance claim for threatening criminal activities to leverage a case in a civil matter, as well as refusing their reasonable duty to communicate and correspond. In response, in the Mecklenburg County Courthouse located in Charlotte, North Carolina, the Superior Court presiding Judge Todd Pomeroy falsely stated, "They owe you no duty." Even if there are violations, there is no legal merit, and arbitrarily ruled in favor of the defense attorneys. Yes, you read that correctly. The Judge Todd Pomeroy stated attorneys owe you no duty to communicate or cooperate. I'm sorry, Your Honor. I do not like to disagree with the court. However, we may need to take a closer look at the American Bar Association's rules on that. The American Bar Association is found here. https://www.americanbarorggroups/litigation/committee/business-torts and fair competition/practice/2016/duty of good faith fair dealing/states. The duty of good faith and fair dealing in general, every contract contains an implied duty of good faith and fair dealing. This duty requires. Let's take another look with what counsel has to say from https://www.upcounsel.com/acting in bad faith. Acting in bad faith is an act of intentional dishonesty that occurs from someone not fulfilling their legal obligations, deliberately misleading someone, entering into an agreement with them with no intention of fulfilling the obligations, or violating the basic principles of honesty in your dealings with others. After the hearing's conclusion, Judge Todd Pomeroy called the defense attorney Heather Connor, who was seen covering her mouth laughing at the Pro Southeast plaintiff, up to the bench for private discussion in front of the plaintiff. The plaintiff watched the Judge Todd Pomeroy cover his mouth with a piece of paper and overheard him ask, "Is he the one?" clearly indicating he had previously spoken with the law firm and had prior knowledge about the plaintiff. This is a direct witness to ex parte communication. This is a violation that supports prior knowledge of the plaintiff. This is a clear indication that communication between Judge Todd Pomeroy and parties without the plaintiff present occurred. This is ex parte communication. This is a violation of Judicial Code Canon 3. The legal merit is steadily increasing and growing for the plaintiff's case. Let's take a closer look at Automobile Code X734-35. http://freedomschool.com/model code of professional responsibility PDF. This amount and type of communication will stand as sufficient evidence for grounds to submit an order of recusal for Judge Todd Pomeroy. You may be outraged by reading this. However, you may be even more disturbed after understanding why the plaintiff seeking to recover damages after a car wreck was representing himself as Pro Southeast in litigation. Where's the plaintiff's attorney? You may have already guessed. Not a single attorney, after contacting over 40 law firms, wanted to take the claim and fight the insurance company. That is disturbing. There are no court-appointed attorneys in civil court for civil matters. The lack of checks and balances in the judicial system allows an imbalance of power for companies who are able to pay and retain attorneys to abuse the litigation process and ultimately abuse your community. How do we implement an insurance reform? How do we solve the imbalance of power?